Introduction to Law class. For the past 3 or 4 weeks, the class has studied, done an in-depth study of 15 Supreme Court decisions relating to freedom of speech and freedom of expression in the First and 14th Amendments. And now they've been divided into teams to look at hypothetical law situations and to write the opinion of the Supreme Court based upon the cases which they've just being consistent with the cases they have studied. And today we have Mr. Chief Justice Barkowski and Madam Associate Justice Patriarco delivering the opinion of the court in the case of Greeno versus Lewisburg.
The argument that the showing of films with explicit nude content may distract drivers on the highway can be sufficient to support the conviction if there's any evidence that such films shown by Mr. Barley Greeno in his driving exhibition were the cause of any accidents, deaths, or other misfortunes. There is no such evidence, leading the court to conclude that the films have not been the cause of any accidents, deaths, or other misfortunes. Because Greeno's driving exhibition did not trigger any material and substantial interference with public discipline, such claim is invalid. The argument that the showing of films with explicit nude content brings vulgarity to and upsets morality and decency in the Catholic school next to the driving exhibition can be sufficient to support the conviction if the students at the Catholic school had no reasonable way to avoid coming in visual contact with the films. However, because the driving exhibition can only be clearly seen from the parking lot of the educational institution, and the parking lot is not at all linked with the educational process of the students, such claim is invalid. The argument that the students are often on campus in the evenings for athletic events is also invalid because students who have any justifiable reason to access the parking lot in the evenings are those students who have access to cars, which automatically puts them at the appropriate maturity level to view R-rated movies. If the students voluntarily occupy the parking lot to watch the R-rated movies shown by Mr. Barley Greeno, of which there has been no record, the basis for accusation disappear upon the instant. The following excerpt will be taken from a Supreme Court case named Tinker versus Des Moines School District. The district court concluded that the action of the authorities was reasonable because it was based upon the fear of a disturbance from altered films with explicit nude content. But in our system, undifferentiated fear or apprehension of disturbance is not enough to overcome the right to freedom of expression. Any departure from absolute regimentation may cause trouble. Any variation from the majority's opinion may inspire fear. Any expression that deviates from the views of another person may start an argument or cause a disturbance. But our Constitution says we must take this risk. And our history says that it is this sort of hazardous freedom, this kind of openness, that is the basis of our national strength and of the independence and vigor of American who grows up and lives in this relatively permissive, often disputatious society. In order for the state to justify prohibition of a particular expression of opinion, it must be able to show that its action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompany an unpopular viewpoint. And it's taken from Tinker versus Des Moines School District. Since no such evidence was found, the conviction of Mr. Barley Greeno by the Lewisburg City is reversed. Thank you.